The Honorable John M. Harris, Judge, presiding. All persons having business before the court drawn near, give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court.
Please be seated. All right, good afternoon. Welcome to the oral argument session here at the 5th District Court of Appeal. As the Marshal said, I'm Judge Harris. I am joined on the panel today by Judge Boatwright and Judge McIver. Two cases on our docket today. In each case, each side has 20 minutes. The appellant can reserve as much of that as the appellant would like for rebuttal. The default will be set at 5 minutes. If you want something other than that, please just let me know and we'll make that happen. If you have any cell phones, other noise-making devices, please make sure those are either turned off or silenced at this point so that the proceedings are not interrupted. And just keep in mind that we are being live streamed on YouTube. All right, the first case we have up today is Holding Insurance Companies versus American Integrity Insurance Company of Florida. Case 23-2368. Here's our counsel for the appellant. Is it you, sir? All right, sir. 5 minutes okay for rebuttal?
That's what I would be requesting.
You got it. All right, you may proceed when you are ready.
Good afternoon. My name is Tyler Chazet. I represent the appellant in this matter, Holding Insurance Companies accountable, as assigned to Stephen Wells. I have great deference for this court and the rights and powers that it has. However, I believe that the position that American Integrity has taken is doing something that this court has specifically stated it cannot do, and that's rewrite statutes. In this circumstance, there is a statute, 627.7152, which applies to assignment agreements. Assignment agreements are defined under that statute, under Section 1B, as a two-part analysis in order for whether it's an assignment agreement under that statute. The first part being that it's a transfer of rights for post-loss benefits. I don't think there's any dispute in this circumstance that my client is seeking payment of post-loss benefits for damages to the property, which would be payable under a policy. What it's not seeking is repair or any other service of that type. The second part is that it is an agreement between to or from a person providing services to protect, repair, restore, or replace property or mitigate against further damages to the property. My client performs none of these services. There's no evidence in the record of the assignment or other which would indicate that my client does perform any of those services. It is.
So as part of the agreement, though, were some of the post-loss benefits, aren't they actually going to ultimately be assigned to somebody who provides those services, Nolan Roofing?
I would.
And that's what the appellee argues. So how do you respond to that?
Well, I respond to that in multiple different ways. First and foremost, the insured would be on that payment, as well as the mortgage company, if one existed at that time. And then, as this court has previously ruled, there is always the right of a party to breach an agreement. And if that insured then said, I no longer want Nolan's on that payment, then that could occur. Now, in this circumstance, what we don't have is any evidence of what those monies actually would be used for. But by doing so, we are already going beyond the statute. In this circumstance, the statute's clear. American Integrity has yet to argue that it is not a clear and unambiguous statute. Based upon that, we need a strict construction. And this strict construction only talks about the person to and from, not a third-party agreement that may be between two other parties, even if the insured says, well, I do want something in compliance with a different agreement that I have at that time or may not have. That's still not the agreement with my client, and that's what matters. We are now not only strictly seeking to strictly read it, but then that would require bringing in third-party contracts to be read in a statute that is plain and clear on its face.
So this was a 2021 claim. Does the AOB statute apply to your client post-2022?
I'm sorry, can you state that again?
We're discussing a 2021 claim here. There was a change to the statute in 2022. Does the AOB statute now apply to your client?
The AOB statute, even though it doesn't apply, that new variation doesn't apply to this assignment. We still,
No, that wasn't my question.
and I was about to go to that next spot. Although that statute itself wouldn't apply because this assignment agreement pre-existed it, I still do not believe that it would apply even on the expanded version where it says including but not limited to services for inspection or those type of services, because my client has never been to the property. They have never provided a service to inspect. They have never provided their beliefs of scope of damage.
How would you characterize the service that your client provides?
I think it would be closer to a debt collection type item, where my client only shows up after the insurance company has reviewed damages to the property, made an incorrect adjustment of a claim, and said the value of damages under the policy are X. And
But a debt collection happens after that debt has been judicially determined, correct?
well, if you're actually, I mean, people are litigating prior to the collection, correct? I mean, you would have to file a suit before that, and somebody said, I'm owed X, and I should be paid it, and then yes, debt collection judgment would then be entered and you would be collecting, but I would say it would be more akin to forcing a breach of contract payment that is due and just seeking financial recovery than it is we are a service provider who helps protect or restore. And this is important under a policy because of what's actually insured is payment for a damage.
How's that not a legal service?
I'm sorry?
How's that not a legal service?
That my client takes on a claim and seeks to recover on it? I mean, there is no requirement that it is litigating a claim. It chooses to.
What specifically do you do for them?
Well, it's in the insured acknowledgement form as well as the assignment where it talks about financial protections as well. There, in most cases, is a proposal for settlement served, forcing somebody to say, well, you know, if things don't go my way, I may be on the hook for additional financial liability. I don't just get to go home and say, well, I was wrong. So there's also financial protections there. There is the safety from having a headache and being a part of active litigation where somebody is calling you and saying, hey, we got 30 days to respond to interrogatories. You need to get in here and you need to assign them and answer, or else we could have hearings in front of a judge where you could be found in penalty. I mean, there are many different aspects of this where there is a protection provided to the homeowner. That homeowner gets the monetary payment that they should have received.
The contract says is, in essence, you save the client time, the expense, the threat, stress of aggravation of litigation, the risk of fees. Isn't the, or could the term services be broad enough to include those, if those are done to protect or repair the home?
I mean, there's
Client
no...
doesn't have to worry about it, but it's getting done.
Well, I mean, ultimately, everybody's seeking payment of money. Now, there's nothing in the policy that says that it must be done for repair unless you're seeking replacement costs, which there is no evidence to suggest that that's where we're at here today. But there are many different other items that could be done. The mortgage company will be on there.
I thought this was a case where you're replacing gutters and a roof. That's not the case here?
Well, I mean, there was a demand, how we define the scope of damages that should have been paid may be through the use of, these are the items that you should have paid for, but my client is not seeking to do those repairs or anything. They're seeking monetary payment. And just as though when we are seeking payment, that money can then go to A, as the mortgage company is protected under the policy to be included on those payments, that could go to lower the mortgage debt. That could go to a vacation if they felt like taking the money and doing other. Often, you know, homes get sold during litigation, and the individuals take the money that was paid out through the claim, and they use it against any sort of lowering of value of the home. There was recently a case in front of the 4th DCA where they even included that even if a home has been sold, you still can recover for the damages to the property. You just can't recover for future speculative damages that for repairs not incurred. So in the circumstance of this home, which there's no evidence to suggest what the money would actually be used for, which I do believe would go as well outside of the statute. But if those monies were paid under even an ACV value, and they had sold the home, that's still money in their pocket, and there's no ever chance of a repair to be performed under that circumstance. It's important to note that at all times, it has been American Integrity's burden to show that somehow my client has performed the services under the statute. I suggest that there is absolutely zero evidence in the record, and they've never been able to show any sort of service of those types.
After the motion for a hearing, the judge changed his ruling, granted the motion. Did he make any findings as to what services he found your client had performed?
That's an interesting question, because there was no rehearing, actual hearing. The original order came out in my favor, or my client's favor. There was a motion for reconsideration filed. We were working to schedule it for hearing, and upon contacting the judge's assistant in order to get time, the next morning there was a amended order finding completely the opposite side of all of the facts without any additional hearing. So it was ruled on both sides from the same summary judgment hearing.
The first order that the judge entered that went in your favor, he just adopted your proposed order.
Correct, and then did the same
verbatim.
Correct.
Because I saw Judge Brzezinski in Seminole County had the same exact findings. So he signed the same exact order that you presented, right?
Correct, Your Honor.
So the judge might have just said, I shouldn't have signed a form order, I shouldn't have just adopted it verbatim, and then went back and looked at a second order that was submitted?
And then looked at American Integrity's proposed order and signed that one. Ultimately, I believe that it's pretty clear from the reading of the statutes, there is no argument about what other services that somebody else may or may not provide would be interpreted into the statute. To do so would go outside of the four corners of that statute, and to apply it to this circumstance where I believe that the assignment's clear, a direction to pay agreement is unenforceable and can be unilaterally stricken at any time by an insured, and therefore even then it shows that repairs may not be made. Or even if the repair company or the contractor that they're using did receive some of the money, that doesn't mean that they actually move forward. There is no contract saying you are actually going to put hammer to nail with that individual with those funds. They could back out and say, listen, I'll give you some money for documenting the damage that I ultimately got paid on, and a giving back for some of the work that they did in helping present what damages were present, and then no repairs are ever performed. All of those things are still outstanding, and those are the requirements of defendant to prove, if even the court were to go that far, which I don't believe it should, that those monies were in fact for repair. And that's not in the record and has never been proven. I will reserve the remainder of my time unless there's any questions.
Okay, thank you, sir.
Thank you.
Good afternoon. Ben Carter for American Integrity, and may it please the court. This case is about HICA's attempt to avoid the requirements of Section 627-7152, which the legislature enacted in 2019 to provide policyholders with some basic protections when granting assignments of benefits and to reduce litigation arising out of those assignments. HICA thinks it's found a way around this statute by splitting with another company, in this case Nolan's Roofing, the actions of pursuing benefits under the policy and making repairs to the insured's property. But like a traditional assignment of benefits situation, the record in this case shows that the purpose of the assignment and the purpose of HICA services is to facilitate repairs to the property. The court should reject this thinly veiled attempt to circumvent the legislature's.
Do they actually perform any repairs to the property?
They do not. There's no dispute that they do not perform any repairs to the property.
And is Nolan Roofing an assignee of these benefits pursuant to the agreement?
Not pursuant to that agreement, however, pursuant to the direction to pay contract, they have essentially informed American Integrity that the insured has signed a contract that says these benefits should be paid to Nolan's Roofing. Also within the assignment itself, there's a reference to, I believe the language is, I want to ensure, or in the assignment rather, it's that any payment on the claim should be made pursuant to the direction to pay contract relative to the claim. The only direction to pay contract we have in this case is the direction to pay with Nolan's Roofing. With it are the documents showing what Nolan's Roofing is going to do is repair the damage to the insured's roof.
Why do we care what the purpose of the services was?
Pardon me, Your Honor?
Why do we care what the purpose of the services they provide?
That comes from the plain language of the statute. So we talked, my opposing counsel gave you the definition of assignment agreement under the statute. And the key portion is to or from a person providing services to repair, protect, restore, etc. The statute doesn't define services. It doesn't say services, or it says services to protect, repair, restore. It doesn't say repair services, protection services.
When you have a general term, don't you look, after you look at the general term of services, don't you start looking at the list of items that are provided?
Correct.
To help you define what the services are?
Yes, and I think
Okay, so where in that list of items is debt collection?
So it's not necessarily a list of items. It's a description of the purposes of those services. It's services to protect or services to repair the property. And here HICA is providing a service to the insured. They're doing something useful or applying their effort or skill for purposes of recovering benefits to fund repairs of the property. And I want to point the court on this issue to the Second District's opinion in Kidwell Group versus American Integrity, which is at 347 Southern 3rd 501. It's a 2022 case. In that case, air quality assessors took an assignment from the insured in return for providing environmental assessment services related to a water damage claim. Like HICA, air quality's assignment actually said that it's not providing services to protect, repair, restore, replace property. And also like HICA, air quality argued in the trial court and on appeal that its services were not within the enumerated services types because they did not actually protect, repair, restore, or replace property. In holding that the statute nevertheless applied, the Second District looked to the purpose of the services. They said because the services were related to repairing the water damage, they fell within the scope of the statute. And specifically, this is the part of the opinion I want to emphasize, the court held that the statute applied because air quality, quote, agreed to provide services as part of the homeowner's effort to remediate property damage.
That's what I wanted to ask you about, because isn't the Second District then reading in language to the statute that's not there?
I don't believe so.
The statute says nothing about as part of the homeowner's effort. They just added that in there. You take that part out, then it says to provide services to remediate property damage. That's what the statute says. So the second seems to have just stuck in this language about as part of the homeowner's effort. How do they do that?
I think that's the Second District interpreting the plain meaning, pardon me, something just flew in my eye, the plain meaning of the language that appears in the statute. As I was explaining.
The statute about the homeowner's effort to protect his property or preserve his property.
Pardon me, Your Honor?
There's nothing in the statute about the homeowner's efforts to preserve or protect his property.
Correct. It's about the services that are being provided, and the purpose of those services is part of the homeowner's effort to remediate property damage. In the Kidwell Group case, it was determining scope of repairs, stuff like that. In this case, it's pursuing benefits under the policy that are going to be used to finance the repairs of the property. So just like air quality in the Kidwell Group case, HICA agreed to provide services, the purpose of which was facilitating repairs of the property. The assignment of benefits and the acknowledgement form that the insured executed show HICA is stepping into the insured's shoes, using its own time, money, and efforts to pursue benefits under the policy.
I'm curious about the word replace in the statute. It says protect, repair, restore, or replace property. It doesn't say replace property with like property or replace property with property. Can property be replaced with money?
That's not an issue that we have dealt with directly in this case.
I'm asking you your thoughts.
Correct.
When you are replacing property, can you replace it with money the same value as the property?
In theory, that's how the policy would deal with it. It would replace it with money.
So if you were providing a service where you were trying to collect money that was owed to a person for property, would that money be replacing the property?
The money could be looked at, yes, as replacing the property. And I think this ties into the point that any money owed under the policy, any money owed under the claim, or if we want to look at it as a debt, as HICA has described it, it's necessarily bound up with replacing the property. The policy is going to value the money that's owed based on the damage to the property and the cost of repairs. And HICA acknowledged in discovery that it's the damages it's seeking in this case are the fair market value of, I think they called it the cost of services to bring the property into its pre-loss condition. There's also a reference in their complaint to damages to bring the property back up to code, to comply with code. So to answer your question, yes, the money is related to necessarily repairing or, in this case, replacing the property. Another case I want to call the court's attention to from the 3rd District, Ajay versus First Community Insurance Company. That's at 352 Southern 3rd 900. In that case, the insureds assigned a Hurricane Irma claim to their children. In the assignment, the children agreed that they would insure maintenance repairs, generally maintain and repair the property as if they were the owners. The original complaint was dismissed because the assignment didn't comply with the statute, and eventually the parties brought a declaratory action to determine their rights under the policy and under the assignment. They, like HICA, alleged in their complaint that they were not themselves service professionals, and that's why the statute shouldn't apply. But the trial court dismissed based on the assignment's noncompliance with the statute, and the 3rd District affirmed based on language in the assignment that was referencing repairs and referencing maintenance. Now, it's true that HICA's assignment is not as express or as explicit in referencing repairs or maintenance. But Ajay was a motion to dismiss case. All the court could look at there was the complaint and the assignment that was attached to the complaint to decide whether the statute applied. Here we have the full record that establishes the relationship between HICA's services and Nolan's repairs. As I mentioned, the assignment and the acknowledgement form state that the purpose of the assignment is for HICA to step into the insured's shoes and enforce the insurance policy. The assignment itself requires that any payment on the claim be made pursuant to the direction of pay. HICA's amended complaint asserts a breach of contract claim based on damage to the insured's property, demands payment for all covered losses, and payment in accordance with the direction of pay. As the basis for declaratory relief, HICA alleges the insured believes that it is entitled to coverage for damage to the property, including payments of all funds necessary to meet code approval. As I mentioned in discovery, HICA stated it's seeking the fair market value of services to return the property to its pre-loss condition. And the affidavit of my client's corporate representative shows the only direction of pay that American Integrity received on this claim is from Nolan's Roofing, and it's contained in a contract for roof repairs. HICA argues that these cases are distinguishable, but the only distinctions they identify don't really have a material difference. For the Kidwell Group case, HICA points out that air quality conceded that its assessment report is used, quote, in furtherance of repairs or replacements to the property. But as I've discussed, the record here shows that HICA's service of filing a lawsuit to collect benefits is no less in furtherance of repairing the property than air quality services. HICA also says the language of air quality's assignment, which said the purpose was to determine reparability, scope of water damage, etc., contradicted other language in the assignment disclaiming that air quality was providing services as described in the statute. Now here, HICA's assignment requires that any payment be in accordance with the direction of pay, and once again, we get to look at the whole record. Kidwell Group was another motion to dismiss case. So we don't have to just look at the assignment. We can look at the direction of pay. We can look at the other stuff from the record I've mentioned, showing that these services are necessarily tied to repairing the property. And HICA also says that Kidwell Group doesn't address...
Necessarily tied to is language that you're putting in there. That's not in the statute. It doesn't say anything that's necessarily tied to repair and replacing. It's just services to repair, services to replace, services to restore.
And services that are facilitating repairs, I believe, are services to protect, repair, restore
But again,
property.
that's a word the legislature could have used.
They could have used it, but the plain meaning of the statute encompasses the services that HICA is providing. It doesn't say a person providing repair services, a person providing mitigation services. It describes the purpose of those services, which is to repair, to protect, to restore. And that's exactly what HICA is doing in this case by pursuing insurance benefits that are going to go to Nolan's Roofing to finance repairs to the property.
You say in your answer brief that nowhere does the statute limit the word services to strictly actual repair, restoration, or whatever. So you think it's broader than just apply to those 5 categories?
Yes, Your Honor. And
If it was broader than those 5 categories, why did the legislature then go back and change it and say including but not limited to, and then also add in inspection?
I think
why
perhaps
was that necessary?
Perhaps the legislature saw what creative companies like HICA were doing and wanted to more clearly state its intent in regulating post-loss assignments of benefits under residential property insurance policies. So going back to, and also I would go back to the Kidwell Group case on this same point, assessment services are not listed in the statute. It doesn't say services to protect, repair, or assess damage. And the Second District nevertheless concluded that's the type of service that can trigger the statute because it is a service that is helping the homeowner remediate property damage.
But we don't have assessment in this case.
We do not have assessment. This is a different type of service. It is no less related to repairing the property than assessing. Collecting the money that's going to go to the roofer to fix the roof is just as integral a part of repairing the property as is assessing, a mold remediation protocol like air quality was doing in the Kidwell Group case. So like air quality, HICA services are part of the insured's effort to remediate property damage, and thus its assignment must comply with the statute. Now going back to the IJ case, HICA argues the language of the assignment contradicted the children's claim that they did not agree to restore or repair property, while here it's undisputed that HICA did not itself perform any repair or replacement work. But that was also undisputed in the IJ case. As I mentioned, that was a motion to dismiss case, and the children in IJ alleged that they themselves were not service providers. That was something that the court had to presume to be true in ruling on the motion to dismiss. That did not mean that their services, whatever services they were providing under the assignment, did not trigger the statute. So in IJ, it was the language of the assignment that defeated the argument that the statute did not apply. Here it's the entire record that belies HICA's claim that it did not provide services related to repairs. So what these cases show us is the key is not agreeing to put hammer to nail when a company takes an assignment of post-loss benefits, but agreeing to provide services that are intertwined with or meant to facilitate repairs. And I would go back to the language that the second used, part of the homeowner's effort to remediate.
You're more focused on that argument than you are what the trial court seemed to rely on, was that there was an assignment ultimately to Nolan's Roofing. You're more general in your application of that. Is that correct?
I'm not sure it would be more general. I think we agree with the trial court. The trial court was perhaps not as specific in its order, but the trial court did point to the same documents that we're pointing to in this case in reaching its order. Specifically, the trial court references the direction to pay in the assignment and the acknowledgement form, the direction to pay contract itself, the demand for payment and the complaint, and HICA's interrogatory responses, and finds that the purpose of the funds sought by HICA is to protect, repair, restore, or replace property or mitigate against further damage to property, and therefore it falls under the statute. I want to briefly address, with the time I have remaining, some of the other arguments that HICA has made. First is that the trial court injected additional language into the statute by applying it to HICA's assignment, and we've touched on this already. The statute doesn't enumerate the specific services or define the specific services. It says services to repair. I think the way it's written is focused on the purpose of the service. Here, there's no dispute that HICA agreed to provide a service to the insured to file this lawsuit, and the record shows the purpose of that service is to facilitate repairs of the property by recovering money under the policy. The legislature did not exclude or exempt this type of service, just as the second observed that the legislature did not exclude or exempt assessment services. Thus, it's our position that HICA is attempting to rewrite the statute to say an assignment to or from a person providing repair services, restoration services, or along those lines. I also want to address HICA's claim that the statute requires one of the parties to the assignment to provide the enumerated services. Once again, this is not supported by the plain language of the statute, which describes the purpose of the services, and I would refer back to the Kidwell case and the Ajay case, which both rejected claims that the statute could never apply to, or could only ever apply to service professionals. And I also want to point to another part of the statute, which is subsection 11, that excludes certain types of assignments or other instruments from its application. And specifically, it's going to exclude assignments of benefits to subsequent purchasers of the property, and also powers of attorney that grant certain persons the authority to act on behalf of the insured on an insurance claim. If HICA's interpretation were correct that the statute only applies to service providers, there would be no need to exclude assignments to subsequent purchasers or to powers of attorney granting people authority to act on the insured's behalf. These assignments would never be subject to the statute because unless the purchaser or the holder of the power of attorney were themselves making repairs. But the fact that they receive a blanket exclusion shows that the assignments might otherwise be subject to the statute. So to sum it up, HICA's assignment is an assignment agreement within the meaning of the statute, regardless of its attempts to disguise it as something else, because HICA agreed to provide services to the insured as part of the insured's efforts to remediate property damage. To hold otherwise would permit HICA to circumvent the legislature's attempt to regulate post-loss assignments of benefits and leave the insured without the protections that the legislature intended to provide. If there are no other questions, American Integrity respectfully asks the court to affirm the order on appeal.
Okay, thank you, sir. All right, counsel, you have just under 8 minutes.
Thank you very much.
Could I ask you to start with that Section 11 statement that your opposing counsel just brought up? And specifically the part that talks about a power of attorney's assignment to a management company. If you were to generally describe the service that you provide, it does seem to be stepping into the shoes of the homeowner. Well, let me just... to act on behalf of an insured as it relates to the property insurance claim. That seems to be generally the service you provide. And I'm curious about his statement that if that's not a service under the AOB statute, then why would it need to be excluded?
Well, I was actually going to start off with Section 11, so that works out. I believe American Integrity's two arguments actually go to invalidate the whole Section 11 argument. In the Ajay case, and I will get to Section 11, just let me get there. In that case, there's a line here that the court found that I think applies here. While not every assignment triggers the requirements of Section 627.7152, that's this assignment. Here, the plain language in Ajay specifically was applicable because they insured maintenance repairs, agreed to maintain, repair, or otherwise take responsibility for various other obligations. That tied them into the statute because the assignment itself was for repairs. Similarly, for Kidwell, they were doing assessment services and those type of items on the property itself and being active in the repair. Subsection 11 could have been an argument if Ajay put that in the assignment, but they were a subsequent purchaser, or they were operating under those ones, then yes, that subsection could apply in order to invalidate the application of that statute. Not every assignment goes under 6277152, but if it applies, that subsection then lets you back out. So there would be scenarios in which a property management company says, yes, I'll take the claim because I'm going to make sure that the property is maintained and repaired. And that's why they would need that subsection 11 exclusion, because there are scenarios where they could apply, maybe not every scenario, but it could apply, and they're getting granted that out. But just like if you're in a car accident and all you have is a homeowner's policy, if the policy doesn't apply, then the claim doesn't matter. In this circumstance, this assignment never fell under 7152, so any argument about subsection 11 is relatively a red herring in this circumstance, since we've never triggered it in order to evaluate if it's an excluded item. Sorry, sir.
Just the observation, though, that if the mechanism by which you got the assignment were a power of attorney rather than the contractual basis that you trigger your assignment with, then that would apply to you.
I mean, if we were agreeing to provide those services that were under the statute, but I still don't think that if my client is never performing any of the services to repair, that we ever trigger it in order to explain that we have a power of attorney to get out of it. So you would still require those services to have been a part of the assignment or agreement, which that has never occurred for my client. Therefore, we would never have to worry about talking about direction to pay, or a power of attorney. In reference to the direction to pay, I want some clarity on that. There was kind of a little bit of verbiage going back and forth about assignment versus direction to pay. A direction to pay simply just says add them to the check as well. There is no actual right transferred. It's not something that could be sued upon. I've seen orders where cases are dismissed because it is not an actionable thing. So my client had the assignment, the chosen action to bring suit, whereas the direction to pay is just please include them on a payment. It is not any sort of agreement to do anything or to accomplish anything other than potentially put them on a payment if the insured, in fact, wants that at some future date. It's our position that any sort of reading beyond what is simply put in the statute would be an incorrect interpretation. My client doesn't perform any of things. They've never been...
Second DCA get it wrong in the Kimbrough case?
In which case?
Did the second DCA get it wrong?
I would believe so. I think that they've expanded the aspects of it. I think that what they were able to hang on to in that case, which is also distinctly different, is that Kidwell Group made the agreement to go and perform services at the property related to repairs in order to get the assignment and ultimately sue, where they said, yeah, we are doing, and specifically in that case, they were discussing that to determine repairability, scope, and categorization of water damages themselves. Those were the services they were providing, which are all in relation to repair, as well as there's other cases for Kidwell Group where it was found that they could sue upon inspection reports if, in fact, those inspection reports were used inside of the actual repair in tying it into a secondary part of a repair. In this circumstance, my client hasn't got anything that's tied that they've actually done that would be tied into the repair scope or what have you.
Could you briefly address the question I asked your opposing counsel about money as a replacement for property?
I don't believe money is a replacement for property. Obviously, if something is damaged or broken, cash may attempt to be an alternative way for you to walk away or legally be provided a satisfaction. But if something is broken, it's still broken. Money's, unless you paper mache it onto the item and put it back together, I can't imagine how money necessarily would be a repair itself.
Well, not a repair, but a replacement.
Or a replacement.
The money is replacing the value of the property.
Well, that would, not go to affect the property itself. That hasn't changed any aspect of the property. I don't think that it's a replacement in the meaning of the word, especially in insurance law, where a replacement is to provide a similar type item in order to, you have a bike that was broken, you get a new bike. This circumstance we're receiving
Well, do you get a new bike, or do you get a check so you can go out and buy a new bike?
depends. I mean, in that circumstance, you could receive money to do that, but I mean, I don't think you're necessarily assigning that. I don't think it's a replacement service to demand a breach of contract. In the end, my client received a chosen action to bring suit and seek monetary damages, whether that be of the nominal amount or ACV amount or other, and they have done that. They have done nothing to the property, and thank you for your time today.
All right, thank you, counsel. Well briefed, well-argued case by both sides. Yes, sir. Of course.
Thank you, Your Honor.
Thank you. All right, our next case today is M.N. as the appellant versus Agency for Persons with Disabilities. Again, counsel for appellant, you may reserve as much of your 20 minutes as you would like for rebuttal. I'll set it at 5 minutes if you want something other than that.
5 minutes is fine, thank you.
You got it. All right, you may proceed when you're ready, counsel.
Thank you. May it please the court, I am Marissa O'Connor, the attorney for MN. So this appeal, we've outlined several different errors that arose through the agency's actions and the final order, but really there's an overarching error that has arisen that caused the rest of them, and that is the agency's failure to follow their own rules. So, and to be more specific, Administrative Code Rule 65G 4.0215 specifically says that a person can be disenrolled for various reasons, one of which would be moving out of state, such as our client did. And when they return, they are to be put on a waiting list until services can be provided. And that is if they have been out for more than 365 days. The rule does not set any end time period. It just says if it's been more than that 365 days, then they must be put on the wait list and until their services are available.
What about the last sentence in that provision you're talking about? Does the eligibility have to be reestablished?
No, it needs to be a level of care as opposed to the eligibility. They need to be able to make sure that they can provide that level of care.
So ADP is not disputing whether your client has autism, correct? I think
Correct.
That's pretty correct. Okay. They're disputing whether he has the severity, whether he meets these statutory factors. That's what you went to the hearing over. Is that generally correct?
Generally,
Okay.
yes.
Was there ever a time in your client's life when he actually was determined to meet those criteria?
Yes.
Okay, so would that have acted as an administrative finality, or should it have?
That is our contention, yes. He was,
Has there ever been, I think it requires a substantial change in circumstances, correct? If there's not going to be the finality. Did the law ever change in regards to these factors, do you know?
Not to my knowledge.
From the time he was approved previously?
Not to my knowledge. He was only gone for 5 years.
Did his autism get better? Did something happen that made him would have made him worse at one point and made him better now?
No, sir. When he moved out of state, it was simply for personal reasons, for the family. It was not due to any medical issues. He was receiving services for autism in Pennsylvania. And then when he returned, he was having the same characteristics. And his mother testified to this, several places in the testimony. She talked about how his characteristics and symptoms were the same, basically the same throughout that time.
Do you think leaving the state is, for a length of time, is that a substantial change in circumstances?
The rule does not specify a change of circumstances for leaving the state. It just says they become disenrolled and that they can go back on services once they can be re-enrolled. And by moving back to the state, he can be re-enrolled. And the problem lies in that level of care determination, because instead of an eligibility determination...
In the rule, it says if waiver eligibility cannot be reestablished, or if the client who has chosen to disenroll has exceeded the time period. So that seems to be two independent reasons why someone would go on to a waiting list rather than be re-enrolled. But one of those criteria cannot be reestablished. Doesn't that indicate to us that there needs to be a reestablishment?
I would say there does not need to be a reestablishment.
Why?
Sorry. Because it was not for medical purposes. It was not because they could not meet the level of care at that time.
Are medical conditions static?
I'm sorry?
Do people's medical conditions not change over time?
They do change over time, but autism is not a condition that is going to get better, that a person can be cured of. And there's no dispute that he had autism. It was they needed to determine the level of care.
Does the severity of one's autism change over time? Does their ability to manage that autism within the world change over time?
There may be fluctuations. In his case, there was not. His problems were the same when he left as when he came back. So there was not an issue of the eligibility.
There may or there may not be, and that's fine. But for the purpose of the rule, you're saying that there doesn't have to be a reestablishment because people's conditions don't change. And I think you're also telling me that people's conditions can change over time. While they may still have the diagnosis of autism, the severity of that autism might change, their ability to manage that autism might change, and frankly, that translates into their need as compared to all of the other people who are on the waiting list.
And right, the need is where the level of care comes in. The level of care, the purpose of that as determination is to determine what the needs are and what they can provide, what services can be provided. So level of care determination is different than the eligibility determination. He had already been determined as eligible. He hadn't changed at all. He came back, he followed the rules. The rules specifically says that you have to let them know you're re-enrolling.
But again, it says if waiver eligibility cannot be reestablished. That seems to me to suggest that eligibility needs to be reestablished.
In this case, it would be his coming back would be establishing that eligibility. He's going back to that same eligibility determination that was previously made. Just like if somebody had that level of care determination made while they were on services or on a wait list, and the level of care could not be provided, the services could not be provided for that level of care, that person would be disenrolled. But if they were able to get to a point where they were back and needed the level of care that the agency could provide, then they have established that eligibility again. But it's all based on the level of care determination as opposed to an eligibility.
Again, the rule doesn't say if a level of care cannot be reestablished. It says if eligibility cannot be reestablished.
In looking at the rule as a whole, it would be, if you're looking at it as a whole, it's when they come back, when they get to that point where they can be re-enrolled, then that is the point where it has been reestablished, and then it's a matter of putting them on that wait list until those services can be provided. And their expert even goes on to say that. I mean, their expert says once the eligibility has been determined at pre-enrollment, then they do level of care assessments on a yearly basis, and to make sure that they can maintain the services and the needs of that client for the services. So in reading the statute as a whole, it's whenever they're able to get back to that point where they can and want to re-enroll, that is when that eligibility has been reestablished. Not that another eligibility determination has to be done. They are treating it as if a whole new application has to be completed and the eligibility. The rule also states that to be able to re-enroll, that the person needing the services lets the agency know that they need the services, that they have the intent to re-enroll, they've been on services before. So that is also part of the rule, and that is what MN did. When he came back to Florida, he called the agency and said, I've been on services before, I want to get back on services. And they didn't even look at the previous information. They didn't look to compare how he was previously to how he was now. It was treated as a brand new application and looking at that point in time, as opposed to how he was before to now. So
the only reason the eligibility had been cut off, it's not that his condition got better, it's that he left the state, correct?
he was disenrolled because he left the state. And we did bring up these issues in a motion for summary judgment. The hearing officer would not entertain the motion for summary judgment. At the hearing officer did not acknowledge this code in the final order. It wasn't even mentioned. And there was no analysis as to this code by the hearing officer directly, even though it had been raised on multiple times. And this is a fundamental error for them, because the agency what they did was they were exercising its discretion inconsistently with its own rules. It was also interpreting the rule that compels a particular action, which would be that going on the wait list after 365 days. But they continue to assert that it is a brand new application. And so their policies and practices are not complying with the rule. They did not consider this rule at all. And they tried to put an end date on it, which there is no end date. It doesn't say if you come back 5 years later, it's too late. It says if it's been over 365 days, here's what you do. They did not do that. And MN did what he needed to get re-enrolled and with his application. And like you said, they don't dispute the severity, or they don't dispute that there's a diagnosis of autism. He had the same characteristics. They didn't look at the previous record to even tell that. And as I said before too, if they were to have done a new level of care for a client who had been on services and not just left the country, it's the same situation. They would have had to do a level of care. If the person couldn't stay on services because it was too high of a level of care, then they would be disenrolled as opposed to terminating eligibility. It's a disenrollment, and coming back and being able to get services later on a new level of care determination would be the same thing. They would have to bring them back and at least put them on a waiting list, at a minimum, to put them on a waiting list until services could be provided, till there's funds, till there's an opening. And that was the other part of this that we had brought up, was the crisis situation. It was...
So one of the reasons why, and this is different than your situation, I acknowledge, but I'm trying to see how this rule works. One of the reasons why you might be disenrolled is let's see, the client no longer needs waiver services. So if after 365 days, the client then decided that they did need waiver services again, by your contention, they should be put back onto the waiting list. And then the last sentence is when the effective date for being put on that waiting list is. And the two examples are when eligibility is reestablished or when the client requests re-enrollment. Now, you're suggesting in your situation that the effective date should be when your client requests re-enrollment.
Yes.
In the scenario where they weren't eligible for Medicaid service, or where they weren't eligible for waiver services, would that be a situation where eligibility would have to be reestablished?
It's our contention that no, it would still be a level of care determination to see whether they could get back on services, to see if they're at that point. But in reading the rule as a whole, it does, I see your point as well, because yes, there's an or there. They don't have to make both.
So there are scenarios within this list that would require a reestablishment of eligibility. You're just contending that moving out of state and moving back into state is not one of them.
I do contend that that is not an issue where they would have to establish eligibility. We contend that this use of the word eligibility in this rule is misleading because they're looking to get re-enrolled, not to redetermine eligibility. They've already been determined eligible, and it's still that level of care. And the agency rules set out what these level of care assessments are to be and what can be provided and how they're supposed to do it and when they're supposed to do it. And it conflicts, if you read this rule as meaning an eligibility to determination, that's conflicting with the other rules that apply to the agency for level of care.
So you're where you're into your
Yes,
rebuttal time.
if I may reserve the rest, if there are no more questions now. Thank you.
Good afternoon, Your Honors. My name is Francis Carbone. I'm the General Counsel appearing on behalf of the Agency for Persons with Disabilities. May it please the Court. This Court should affirm the lower tribunal's final order for the following three reasons. The first is that due to the dynamic nature of the developmental period and the requirements in statute and rule, APD must comprehensively review eligibility whenever a new application for services is received. The second is that Rule 65G 4.0215 only speaks to enrollment and not eligibility. It also has a special carve-out for a specific circumstance in the rule. And lastly, the burden was properly placed here on the appellant because administrative finality does not apply where there is a significant change in circumstances.
It's a significant change in circumstances here.
So the appellant moved out of state for 5 years. I think it was something over 2,000 days.
So time is the significant change in circumstance?
I think that creates a possible change in circumstance. Here, there was more than just time. There was the fact that in Pennsylvania, the appellant received different treatment modalities and services which may or may not have ameliorated the presentations that are required under APD's eligibility rule. And
So if he was once determined to have need of services, why is there a need to have another determination? Solely because he moved out of the state. Wouldn't the eligibility just be related to whether or not he was back in the state, the very reason that you terminated the services in the first place?
Yes, sir. The statutes do not draw a distinction of types of eligibility. In fact, in Section 393.065, subsection 1, it says that only clients who are domiciled in the state are eligible. It also says in subsection 9 in the 2021 version that the agency must remove those from the waiting list who are either not eligible or not domiciled. And Rule 65G 4.015 plainly states, in order to be eligible, one must. And it has 3 boxes that you need to check off. One is being over the age of 3, the other is having a condition that's qualifying, and the third is being domiciled in the state. So it is those rules.
Has anything changed in the law as far as the factors when he was originally determined to need services to now?
No, Your Honor.
So nothing changed from when he originally got the services to now legally, is that correct?
The requirements, no.
Requirements?
And that dovetails into another point that the agency would like to make. Rule 65G 4.014 defines autism as being pervasive, which means that it has to be always present and without interruption. It also has to be of an extended duration, which means that the condition reasonably can be expected to continue indefinitely into the future. And it's those 2 elements that caused or raised the question about...
Admit that in your brief, though, correct?
I beg your pardon?
In your brief, don't you state that he has severe autism and it's going to go through into the future?
We admit that he has a diagnosis of autism. We do dispute that the conditions and the presentations were not necessarily severe enough in order to qualify for eligibility. And this was adopted into the final order in paragraphs 26 and 27, where the hearing officer virtually adopted the agency's expert's testimony, which starts around page 204 in the transcript, that the appellant's presentations were markedly different at that time. For instance, he makes eye contact, he stays on topic and makes appropriate comments, uses language for a variety of functions.
I'm not disagreeing with anything that the hearing officer found in regards. I'm just wondering why he has to have this determination again. Is this done in every case with every individual?
In the developmental period where the requirements of the condition are pervasiveness and extended duration, yes, it is. And Your Honor raises an interesting hypothetical because of the way that the statute is written, where eligibility is a binary question, even if the agency did not have information that an individual left Florida, it would nevertheless still be obligated to check whether or not somebody lived in Florida whenever they were coming back to the waiver. It would be one thing if all of this occurred outside of the developmental period, and the manifestation of this under the rules was not changed. However, here, nearly 40% of the developmental period was spent outside of the state, and after he had been disenrolled and determined to be ineligible.
The determination of ineligibility was based simply on relocating?
No, Your Honor, it was both. It was considering both the condition as well as the domicile. And here... When was he ineligible? At what point did he become ineligible? He became ineligible when he moved out of state in 2015.
Okay, so to get back to Judge Boatwright's earlier question, the only substantial change in circumstances between, was it 5 or 7 years that he was gone, is that he came back and time had passed.
The agency disagrees in that it appears, and this was discussed extensively at the hearing, that those different treatment modalities seem to have an ameliorative effect on the presentation. And because the severity component is key here, the agency needed to re-review that. In most instances, this is a pretty simple review if you take one of the other developmental disability conditions. Here, it's more intense because of the specific...
So I'm looking at some of the other reasons for disenrollment. Let's look at the client no longer meets level of care for admission to an ICF IID. Can I read from that there is some sort of regular monitoring of the condition of the folks who are receiving waiver benefits to make sure that they still are at a specific level of care?
Yes, Your Honor, that's exactly correct.
And that if you live out of state for, say, 5 years, that consistent monitoring is not happening.
That's also correct. Every year, a client who is on the waiver gets what's called an annual status review, and it ensures that the person is still eligible, which means that they have a condition and they are domiciled in Florida. It also ensures that this level of care component is being met.
So other conditions that might disenroll you from the program are not evaluated at all during that period of time if you're not domiciled in Florida?
No, the agency can't conduct those reviews if you're outside of the state. It has no information about what treatments you are receiving, especially within a very dynamic period of one's life, the childhood and adolescence. And it was that change, not only the passage of time in a critical period of life vis-a-vis these requirements, but also the treatment modalities that were had in Pennsylvania. And Your Honor brings up a great point about 4.0215. I would say this flush left position is opaque at best, but a nuanced reading can provide some transparency. The list of factors and the flush left provision use the word choose only twice. It's in that first element where the client or the client's legal representative chooses to terminate participation in the waiver, and the next time that verb appears is in the second sentence where it provides an alternative, that if waiver eligibility cannot be reestablished, or if the client who has chosen to disenroll has exceeded the time period, then they cannot return to the waiver and they're put back on the waiting list. The rule specifically contemplates that some eligibility determination is going to happen here. It does not. The fourth sentence is actually a mirror of the second sentence, and it's saying that the new effective date is the date eligibility is reestablished. Like
you're skipping over a sentence. It says when this happens, the client is added to the pre-enrollment category of clients. Doesn't say anything about having to be redetermined eligible. And you argue in your brief here that you guys made him submit a new application to establish eligibility, basically because the rule didn't say you couldn't. Well, the rule doesn't say they have to either.
That's correct, Your Honor. However, the statute, the 2021 version of 393.065, subsection 9, it's now subsection 10 in the current version, says that the agency has to remove from the waiting list any individual who is not eligible or is domiciled outside of the state. So even if that were true, the agency would be mandated to remove that person from the waiting list if they can't determine eligibility.
Why isn't the eligibility then related, reestablishing eligibility is kind of based on Judge McIver's question, based on the reason for termination? So if the reason for termination was he left the state, why can't I read this rule to say reestablishing eligibility as he's now back in the state?
That's a great question, Your Honor. That's because that essentially touches on administrative finality. And here, there was that significant change in circumstances. There were new facts, there were changed conditions, and there were additional submissions. There was a litany of evidence that was presented at the fair hearing that didn't exist in 2015. And so, at that point, Section 393.065, subsection 1, buttresses that conclusion, that only clients who are domiciled in the state are eligible. And then when you look at
So at the hearing, then you're saying that the argument was not only left the state, but that his condition got better?
Correct, the presentation did. And 393.065 does not, 4.015, Rule 65G 4.015, doesn't make a distinction between types of eligibility. It simply says, in order to be eligible, one must. And then it lists a series of factors that are sine qua non, and without which, then all of eligibility falls apart.
So, reading the rule, it does seem that in this instance, the client is added to the pre-enrollment category, does apply to both waiver eligibility cannot be reestablished, or if the client who is chosen, et cetera, et cetera. Since the rule does seem to indicate that you have to be added to the pre-enrollment category if eligibility cannot be reestablished, what does it mean to be added to the pre-enrollment category without an effective date? I assume you cannot put an effective date down until, in one of those instances, let's set aside moving out of the state, but in one of those instances where you were disenrolled and clearly need to meet re-eligibility requirements, if you never meet re-eligibility requirements and you're put on a pre-enrollment list with no effective date, what does that mean?
I think it means that you're simply, the rule makes you choose. And it's either, depending on the circumstances, you're either going to be determined re-eligible and have that new effective date, or otherwise, you're going to be put on once you request it, depending on the circumstance. So I think...
Well, I assume everyone requests it.
Sure, and that kind of shows how untenable the other interpretation of this rule is. One needs to pick. Either your eligibility is reestablished, because again, we cannot put anybody on the waiting list who is not eligible, or in a circumstance where you've chosen to disenroll, then that new effective date becomes the date that you request. The rules and the statutes do not comprehend being put on the waiting list when you're ineligible. And so what that would mean, if an eligibility determination is not made, then there simply isn't an effective date, because you're not being put back on the waiting list. You're simply ineligible.
The source of the ineligibility was the relocation, lack of domicile. Isn't that cured by moving back to the state?
Yes, Your Honor, it is.
So they have to re-establish eligibility if they've eliminated the cause of the original determination of ineligibility?
In certain circumstances, yes, and this is one of those circumstances where there's been this significant change and where there's been all of this data and information that has happened during the critical developmental period, which the rules and statutes focus APD back on. It would be one thing if Rule 65G 4.014 did not say that it didn't have to be pervasive and that it was only a moment in time. Additionally, it would be another thing if it didn't say that it had to be of an extended duration. And so all of that evidence that was newly presented from Pennsylvania touched on both of those factors. Those were significant changes that were material to whether or not there was eligibility. At that time in 2015, I would completely agree with Your Honor and the other side that the only infirmity was moving out of the state. And that's why the flush left provision of 4.0215 contemplates that situation. However, since we're past 365 days and we are unsure of either the pervasiveness or the extended duration, then the agency had to reestablish that eligibility. And the statute and the rule backs it up that there aren't different types of eligibility. It's a binary question whether or not you're eligible. And then once you throw in the specific circumstances of this case, the agency was mandated by the statute to conduct this review.
So, and I'm going to dumb this down a little bit just so that I can follow along. If we were to take appellant's reading of the rule and eligibility was maintained and eligibility never went away, so when you came back and were domiciled again, that was cured, and you were to put the person on the pre-enrollment category, waiver services became available, they started receiving their waiver services within the next year, they'd have their reevaluation period, correct?
That's correct.
So your contention then is that at that reevaluation period, if it was discovered they were no longer eligible because their condition had changed, you would have been violating the law for that period of time.
Yes, for that year, and that's why that review is conducted on the front end, because, again, 393.065 says that we must remove from the waiting list any individual who fails to meet the eligibility requirements. There's only one way for the agency to figure that out, and that's to do a comprehensive review of the severity of the conditions to make sure that they're meeting these dynamic prongs.
Talk to me about the difference of inquiry, and I realize you only have a little bit of time left, but the difference of inquiry involved in an eligibility determination and in an annual reevaluation. Is one a more depth probing than the other?
Yes, the initial determination of eligibility is comprehensive. It's going to look at all of the factors that are listed in rule, and in this case, 4.014. Additionally, what happens at the annual review level is this level of care determination that, but for the provision of waiver services, an individual would need to be placed into an intermediate care facility for the developmentally disabled. And it is that process that is what is at issue here. And in those annual evaluations, most of the time, there's not that significant change in circumstance because it's happening within a year, not 5, 6, or 7 years.
Not necessarily relevant to this case, but just off the top of your head, how many people are on the Medicaid waiver waiting list currently in Florida?
Around 35,000 people.
Okay.
So to conclude, Your Honors, it was the constellation of factors here that compelled the agency to conduct this eligibility review. It was due to the dynamic nature of the developmental period. It was due to the specific condition that was asserted. It was due to the significant change in circumstances by having nearly 1,500 pages of additional data to review. And lastly, 4.0215 does not necessarily preclude an eligibility determination, nor does it grant individuals who have exceeded 365 days a plenary right to re-request waiver enrollment and be placed on the waiting list. As we have discussed, the agency has to remove those who are not eligible, and it's for those reasons that this court should affirm the final order of the lower tribunal. Thank you.
All right, thank you, Counselor. All right, 4.5 minutes.
Thank you. I'd like to propose a different reading of the word eligibility in the specific code, the 4.0215. In reading that code and that rule, it's about re-enrollment or disenrollment. So when you look at the word eligibility, it can also mean just eligible to re-enroll. Not just requesting a re-enrollment, but is the person eligible to re-enroll? Not are they eligible for services, period. And the agency continues to treat this as a new application. They are talking about the developmental period, the manifestation. That's already been determined. He has a diagnosis of autism. He was on the waiver when he left. He was getting services. He was 5 years old, in 2008 when he first was determined eligible and was put on the waiting list. He was 10 years old in 2013 when he was enrolled in services. He had already been determined autistic then. He was determined to have the diagnosis of autism and the severity and pervasiveness required under the code for the agency. They are now treating this as a new application making him show it all over again as if he just was diagnosed with this and what his needs are. They have said that the circumstances changed, his condition changed in that 5 years. Well, that would be determined in a level of care assessment just as much, and the level of care assessment would then say if there were, let's say if there were changes in his condition, then the level of care assessment is going to say, yes, we can provide these services, we can meet these changes, we can meet the level of care he needs given these changes. Nothing changed, though. He did not have changes. It was testified to that he continued to have the same issues and the same problems. And he has school records from Pennsylvania that have the same issues.
Did the hearing officer disagree with that?
The hearing officer disagreed completely. He did not.
So that was more of a factual finding on his part, correct?
On his part, yes. I mean, we brought up this rule and that this was a re-enrollment, not an eligibility issue, that the burden should shift to the agency and should not have been placed on MN. There was little discussion at the hearing about that, and the hearing officer just said, no, I agree with the agency, burden doesn't shift.
Does your client have any ability to get services other through this process, other than private pay? Is this the only avenue that he has?
No, he would have to go through the Medicaid waiver. And his family is in a crisis situation right now. He and his family, they've been living in an RV. His father and mother have had anxiety issues because of this. His father's was so severe that it created cardiac issues as well. He had to move out of the house for a period of time. This is not, it just happened. This has been an ongoing issue, and he requires these services. So we respectfully request that the decision be reversed and MN be put on the wait list at a minimum, if not provided the services he needs. But he does need a level of care assessment and to be able to give him the services that he needs. Thank you for your time and consideration.
Okay, thank you both very much. Again, a very well-briefed, well-argued case. This time, the court stands in recess.
All rise.